You have to wait till Rashu pops up the Facebook Live to see it.
Gotcha.
It's on the,
Yeah,
make sure you're on the Buffalo Area Chamber of Commerce page.
yeah.
It'll have, it's got a bison on the cover photo.
Mm-hmm.
There we are. He's popped it up now. And don't forget to record. And I'm going to mute now.
Okay, thanks. All right, I think we can go ahead and get started. Hi, good afternoon, everybody. It is top of the hour, noon, on July 16th, and thank you for joining us. This is our monthly business speaker event. My name is Rashu Mahalaha. I'm the economic advisor who is working with the GROW program in a variety of our communities in South Central Missouri. Some of the communities I'd like to thank, some of the chamber leaders who really helped make this program happen. I want to begin by thanking our chamber leader in Buffalo, Tanya Watson. Tanya, thank you for your help with today's speaker. I would like to thank Shannon Walker in Aurora. In Mount Vernon, we have Pam Dudley. In Herman, we have Melissa Lensing. In Marshfield, Casey Matthews. In Eldon, Melissa Knox. And in Sarcoxie, we've got the mayor and the chamber team who are helping get the message out to the local businesses. So we appreciate all of the local chambers, local leaders who are involved with the GROW program, really helping promote the opportunities for business growth, community sustainability that we're focused on. We've got a wonderful speaker with us today. Before I introduce our speaker, I'd like to just take a moment and share with you a handful of tools that are at your disposal. Just want to make sure that you're aware of these. So if you'll just give me a moment, I will share my screen. So the name of a tool that's available to our business leaders in the community is called business911.org. You can click on Grow Missouri. When you click on there, you will come to a site that looks something like this. There's a variety of links available for small businesses, mid-sized businesses that may be looking for some support. I want to highlight two specific areas that hopefully are helpful to you. One is all of our events, all of our educational series. We've had about 20 events in the last year and a half, 2 years. You can see a history of the recordings of all of our events. So please feel free to access those. Each of our events is really what we've tried to do is develop content that you, our local businesses, have said is important to you. We've tried to bring in speakers that are from your community, who understand the life, the challenges, and the opportunities. So hopefully this content is much more relevant to you. The other piece I want to highlight is there is a local jobs board that's available to some of our communities that had joined the GROW program early. This year, we've had several other communities join. We don't have you yet activated on the platform, but do want to let you know that there's a wonderful platform that shows you local job opportunities that's on the Business 911 platform. So hopefully you find that information helpful. One last note I'd like to make is, if you wouldn't mind, please take a moment to provide us your feedback on thoughts on today's content. We're always looking for ways to make our information and content helpful, and hopefully with your feedback, we can continue to do so. So there's a link there. The name of the website is www.tinyurl.com/grow, G-R-O speaker. You can type that address in, and that'll take you to our survey, or you can just scan that QR code that's up. And either way, you'll be able to access the survey, and we absolutely welcome your feedback. We were also syndicating our content today on a handful of chamber Facebook pages. So if you're an individual that's on the Facebook watching the content there, please feel free to type in your questions in that chat room. We're going to be monitoring all of our various Facebook pages and certainly posting those questions to our speaker today. Okay, so without further ado, let me stop sharing my screen now. I'd like to introduce our speaker. The speaker today has a distinguished honor. He is the only speaker to date who's gotten a chance to speak twice to us. So Travis Elliott is an attorney. Speaking to him earlier, he's a colleague, and he's from the local community. He's born in Springfield, passionate about the community, knew early in his life that he wanted to do something in the legal field. Got his undergrad in political science and philosophy, and then from there went to University of Missouri and got his law degree. Travis and his firm do really incredible work in the region. Travis represents many counties, communities, various institutions in our rural communities who are looking to navigate the world. You know, normally there's plenty to keep Travis and their team occupied, but certainly these days with COVID-19, we wanted to invite Travis to the conversation because we wanted to know, you know, as small business and mid-sized businesses in our community, what are some of the topics that we have to be thinking about? And Travis is going to share with us what patterns he's seeing, what are some concerns that he thinks small business owners can be thinking about, and how to navigate potentially some risks. So without further ado, Travis, thank you so much. We so appreciate everything you do. We appreciate your time and sharing your insights with us. The floor is yours, sir.
Thank you, Hirshu, and Tanya, thank you for having me from the Buffalo Chamber's perspective. So Hirshu and I were talking about kind of the scope of the discussion today, and you know, I'm happy to answer any questions touching on the issues I'm going to discuss. So feel free to stop me at any point in time. But obviously, the past 90, 120 days for small businesses, everyone has been very tumultuous in different ways. It's affected everyone differently. Certainly from the legal practice standpoint, I was thankful to be busy before COVID hit, but the coronavirus has kind of changed the way everybody does business and thinks about, what business is going to look like in 6 months and a year. And so there's kind of a couple of categories of subjects that I want to talk about that I think would be particularly relevant to this group of folks that are participating today. And I don't mean to suggest that these are the only issues folks are dealing with, but I certainly have a perspective with respect to representing, local governments and small businesses. I represent quite a few businesses in the ag sector, which is particularly important to Southwest Missouri. And so there's just a lot of different issues that I could talk about, but I'm going to try and be fairly disciplined to the extent that I can in the issues that I'm going to talk about today. And so one of the things that Horseshoe and I kind of talked about in anticipation of, this meeting today is, kind of the legal liabilities related to COVID. And that comes up, it has come up a lot in a number of different forms. I think that small businesses, it's already difficult to have a small business and to operate it. Oftentimes you're the receptionist, you're the president, you're the CEO, you're the bookkeeper, and so on and so forth, or at least a very small handful of people are responsible for all those duties. And so whenever COVID first came into our vernacular, it kind of changed the way that we do business in so many ways. Suddenly people were scrambling to determine, whenever stay-at-home orders started coming through, how does this affect my business? How does this affect my employees? How does this affect the supply chain? How do I get my product or services out to the public? Does it affect my ability to do that? And so, now we've kind of, at least in Missouri and particularly Southwest Missouri, we've kind of moved from the dynamic of, the stay-at-home orders to, some communities are imposing mask ordinances and what effect that has on your business, depending upon whether you're public facing or not. And so, I think everybody is, regardless of your bigger view of the issues and the problems, this affects everyone in some way, shape, or form. And of course, from my perspective, I do a lot of labor and employment work representing employers. And so one of the big issues that I've spent, a significant amount of time dealing with over the past 90 or 120 days are those employment issues, and so some of those, specifically, Congress passed the Family First Corona Response Act, and that imposed a new obligation on employers under certain circumstances to provide, up to 80 hours of paid leave for folks who are subject to an isolation or quarantine order, or folks that are experiencing symptoms of COVID and awaiting a diagnosis or have been, tested positive. And so that was one of the new legal requirements that was imposed on, employers, regardless of your existing sick leave and paid time off policies. And so that's been a really big issue, and how to navigate that has been, a frequent subject of questions and discussions that I've had with my clients. It also, impacted folks in the sense that if you had a stay-at-home order, you were dealing with at least earlier in the year, schools being shut down, childcare providers being shut down. And so, in that same FFCRA legislation, Congress modified how the Family and Medical Leave Act works with respect to folks who aren't able to come to work because their childcare provider or school was closed down. And so, that might or might not have affected some of the folks at this conference today, but those are some of the issues from an employment perspective that we've been dealing with and seeing a lot of. One of the other kind of employment related issues that we've been seeing a lot is, what are the boundaries that an employer can, engage in to both protect its own workforce and its employees, and their health and safety, as well as protect, again, if you have a public facing business, what kinds of things and measures do you need to take to, protect the public and to take preventative measures. And this is probably very unlawyerly of me to describe it in these terms, but what I've been kind of emphasizing with all of my clients, regardless of what sector of the economy they're involved in, is, I think a lot of these decisions do require some technical expertise and some thought put into them, but I've encouraged everyone to engage in, let's have a steady hand, let's use some common sense, let's take these risks seriously, but let's also not make molehills into mountains. And I think that that's a pretty good philosophy of use for pretty much anyone in any sector. I mean, what we've seen is a lot of folks on various ends of the spectrum, either going too far with the pendulum swinging one way or the other. And so that's what I've tried to encourage my clients to do, because it's easy to kind of get swept up in going one direction too far, too fast, and too wide and too deep. And so I think that that is a very important principle to apply. And so, the federal government has given some insight into some precautions that employers can engage in. For example, taking temperatures of employees to make sure that they are not, exhibiting a fever. The Equal Employment Opportunity Commission has said that that's okay. Similarly, with respect to, pre-offer, pre-offers of employment, I mean, certainly you can screen employees for COVID, because one of the, there's a couple of considerations that I see a lot, particularly in small businesses. If you're fortunate enough to be able to stay open in March and April, or if you weren't, but then more recently you have been able to reopen your business and be operating, the risk that everybody feels, I think, either verbally or maybe in your head is, if you have a very small workforce that you depend upon to provide goods and services, if someone were to contract COVID and get shut down and be subject to, a quarantine directive, or your entire business could very quickly be harmed by that. And so what I've seen is, again, employers for the most part are taking reasonable preventative measures to, to make sure that they monitor their workforce and protect them, and make sure that, folks aren't coming to work who are sick, and to make sure that you're able to, at least be proactive and address those issues as quickly and as reasonably as possible. Obviously, employers have been engaging in a lot of additional sanitizing and cleaning, and, again, trying to protect their workforce and the public. And I think all of those are good, reasonable, best practices to engage in. I think depending upon the nature of your business dictates kind of what level of preventative measures you need to and should engage in. Everyone's business is different. The amount of, person-to-person, face-to-face interaction you have is different. And so to cast broad strokes about what everyone has to do or shouldn't do is difficult. And there's a lot of information out there. There's a lot of misinformation out there. And so I don't claim to be the expert on the public health issues. What I've recommended my clients do whenever they have questions is, first we kind of start with specific to COVID. You look at the CDC guidelines, you look at what in Missouri the Department of Health and Senior Services is recommending. You look at what your local health department is recommending, and then you kind of take all those pieces together and you aggregate them and you try to separate the things that are reasonable and viable options from those that may not be reasonable and viable for your business or your circumstance, and you try and make the best decision that you can. I think one of the things Horseshoe and I were talking about is it's sometimes it's difficult to separate the issues that you need to be concerned about and maybe the issues that seem to be of concern but maybe aren't. And whenever you talk about the employment context, especially whenever it comes to COVID screenings and whatnot, I, as an employment lawyer, I'm always focused on protecting the employer from charges of discrimination and complying with state and federal laws about non-discrimination and not retaliating and those sorts of things. And just a good example of that, where we've kind of seen a shift in the federal government's opinion about those kinds of things, is, like serological testing for COVID, initially looked like it was an acceptable practice, even though it is considered a medical exam under the ADA. But more recently, the EOC has said that it's not likely a permissible practice. And so, it's very difficult I've always said this from my perspective, being a small business owner, it's very difficult to run a business as it is, much less keep track of kind of changes in the law and changes in what are recommended best practices. And so those are some of the issues that I've been seeing a lot and dealing a lot with. And so that's one category I wanted to at least spend a few minutes talking about, and I'm certainly happy to answer any questions in kind of that employment context. Moving on, and I don't know, Hirshu, if we need to stop for questions or if you want to wait to the end. What's your preference?
Yeah, Travis, a handful of questions have come in, and we just want to throw this out there. So many of our small business owners do not have a sort of a standing attorney relationship. And so is this, how do small business owners, I mean, especially these days with a lot of pressure that they're feeling economically, is this a time when they should be proactively at least building some relationships, just in case? I guess, how does it, in a world where there's so many priorities competing for your attention for small business owners, how should they think about developing and having a formal relationship with an attorney?
Sure, it's a great question, and of course, it's probably the worst question ever to ask a lawyer, and I'll probably give a response that's not typical. I feel like I have pretty good perspective because, I mean, because we represent so many local governments and small businesses, I mean, legal spend as far as costs is always it's a concern. I mean, regardless of whether you've ever worked with, legal counsel or not, I mean, everyone knows, I mean, there's no doubt, I mean, legal expenses are high. And one of the interesting things about my practice is, I mean, I spend probably 70+% of my time doing day-to-day general counsel work. I'm either on the phone or responding to day-to-day questions. Only about 30% of my practice is litigation. And, I kind of view myself, I mean, if you analogize it to the healthcare system, I mean, I kind of view the kind of legal work that I do as going and getting your annual well-being checkup. I mean, I'm oftentimes, and I mean, I'm not trying to, make a sales pitch, but I'm oftentimes able to at least walk, business clients through questions that they have in a fairly short amount of time, because, you get very similar questions time after and again. And it's kind of a preventative approach. And I realize that doesn't always fit within budget or time needs and what have you. And kind of how I look at it from my perspective, at least, is it seems like most of the time for my clients who call me before there's actually a problem, we can, number one, figure out, is there actually a problem we should be concerned about? If there is, what can we do about it to try and prevent it on the front end? And I think that if you looked at probably my book of business and the time I spent doing general counsel versus litigation work, I mean, I suspect that my clients that regularly call me with questions before there's a problem, or kind of in the middle of the question about, do we have a problem and what we need to do about it, even though it's a little bit of an investment now, I suspect, and of course you never know, because if you prevent a problem, you never know that there would have been one, right? But, litigation is expensive. And, oftentimes one of the conversations whenever litigation comes that I have with clients is, what's the desired outcome here? And then kind of work back from that. And I mean, one of the conversations that I almost always have is, what is this going to cost? And that is, there's no doubt whenever you get into litigation, it's going to be expensive. It's going to be time consuming. And even if you prevail, you're not going to feel like you did. I mean, even if you win, you're still going to feel like you lost. And so, I don't know, it feels like at least knowing when you have an issue that maybe you need some professional guidance on is a really helpful piece of that. Because you don't always need to call legal counsel, but sometimes you don't know if you do. And so calling them is kind of that preventative measure. And so, I guess it's kind of like asking a car salesman if you ought to buy a new car, but I would much rather work with a client to prevent a problem than have a lawsuit, because rarely does anyone feel like they've won in a lawsuit. And so probably depending upon the nature of your business and kind of, it will always feel like you're too busy and you don't have the resources to spend. But, for the most part, I think that regardless of whether you're talking about our firm or other firms in Southwest Missouri, the old saying of an ounce of prevention is worth a pound of cure, I think really does have some merit, because, let's say you spend, a couple $100 on some counsel and advice in advance. That pales in comparison to spending 10, 20, 30, 40, 50, $100,000 in a lawsuit. And sometimes there's no risk of a lawsuit, or there's very little risk, and that can be, that can be clarified pretty quickly. So I rambled a lot there. My apologies.
No, that's great. Let me ask another question, and maybe this can segue into, I believe, where you may be going next, which is, broadly speaking, we may be able to categorize businesses in two distinct categories. One is those businesses that have an extensive amount of customer client engagement, retail businesses where there's a constant flow of individuals. So there's maybe that type of a business. And then the other type of business is maybe a more business to business organization where there aren't necessarily that many clients or customers that you're seeing on a regular basis. And just sort of thinking about those in two different categories and the associated risks in this COVID environment, if you can just sort of weave that into some of your guidance for the businesses, because I believe there may be distinct considerations that those business leaders need to be making, depending on whether you're in category 1 or category 2. So just any guidance you have on that, please. And you don't have to answer that question specifically, just part of your next topic, you can cover that.
Sure. So I think one of the common concerns or issues that comes up, regardless of whether you are a public-facing business or not, that I was going to talk about, but I think that fits into that question is, one of the things during COVID that we've seen a lot for various reasons is, contractual obligations. And depending upon which side of the table you're on, lots of businesses, just because of the nature of what they do, have lots of contractual obligations, both as a provider or a receiving party of services or goods. And, we've seen that have a very large scale effect on businesses. We represent a lot of clients who have conferences and schedule conference centers and large public gatherings and whatnot. And, that was one of the first big issues that COVID kind of hit us with as far as legal issues is, does this public health issue justify terminating contracts for, contracting for conference centers and food and lodging and those sorts of things? And so I think that kind of contractual obligation issue is a pretty broad-based issue that most any business has to deal with, with notwithstanding COVID, but certainly COVID has brought it to the forefront. And so that's probably one of those additional preventative measures. A good written contract is like a good fence. Good fences make good neighbors, and good, well-written contracts make good business relationships. And it's created a lot of challenges, because I know that partly because of restrictions in other countries and, even within the United States, it has messed up various supply chains as far as raw materials or actually, manufactured goods. And so, one of the things as a lawyer that I kind of dread is oftentimes a contractual obligation kind of goes downhill between two business parties. And oftentimes a whole bunch of things are said and done, and then folks realize they have a problem, but it's sometimes too late to really fix at that stage of the game. And so that kind of goes back to my prior point about, you kind of need to know, do I have an issue here that I may need to seek some counsel on? And so those contractual obligations have been kind of a real challenge for folks. Moving more to the point of the question, I think from a COVID standpoint, some of the basic principles apply to both of those business categories that I've already mentioned. Keeping your workforce, safe and healthy, making sure that, the public is not subjected to, unnecessary risk. And, as a consequence of that, your business being subjected to potential claims. I think that's one of the interesting things about COVID is that we don't actually have the answers to is, what is a reasonable and tolerable level of risk that everyone's willing to accept? And that kind of ties in with the discussion about, mandatory mask orders and those sorts of things about, what level of risk is any individual business willing to accept? I have business clients who are taking temperatures of every person who walks through the door. I have some who are not taking those approaches, and testing is the same thing. And so I think what's hard about this situation is it's somewhat unprecedented in the breadth and depth of the effect it's had on everyone. And at least from my practice, I don't know that I have seen a lot of significant differences depending upon that kind of dichotomy that you described as far as, public facing versus non-public facing businesses. A lot of the issues are the same, workforce issues. It does, I guess, complicate it whenever you have members of the public who maybe aren't necessarily under your supervision and direction as far as, do you require your members of the public to have a mask or not, and those sorts of things. But beyond that, the issues that I think businesses and local governments and nonprofit entities, they're all dealing with the same issues. It's just the manner in which those issues are affecting businesses are somewhat different, depending upon what they're doing. I haven't seen a lot of that distinction, at least in the issues that have come up for me.
Very cool. Thank you, Travis, for that clarification.
Were there additional questions kind of on that?
That's it for now. Okay. That's it for now.
Very good. A couple of other things on the contractual issue that is very difficult, and I've had this come up a couple of times in the past couple of weeks, is we don't really know, how this public health issue is going to play out over the next weeks, months, year. Many of the events that, require a lot of advanced planning. We saw this in March whenever big events were planned for April, May, June. I definitely encourage any business who has those sorts of obligations, both, now or going into the future, have a good written agreement before you do anything drastic as a result of COVID's impact on your business. Take a look at your agreement. One of the things that I see, and I think this is just good general practice, but it's affected the COVID issues a lot, is, before you make a business decision that could have a material effect on your operation, if you have a written agreement, look and see what it actually says. Because sometimes folks do things without going back and looking, and then it's very difficult to unring that bell. One of the other things that, just as a general suggestion goes, is oftentimes what I find is before I get involved in things, parties have a tendency to kind of draw their line in the sand without really having, a good, clear understanding about what their position is and should be. And so sometimes folks end up kind of boxing themselves into a corner with, business relationships and contracts that then it's very hard to walk away from or kind of walk back. And so what I like to do whenever I get clients calling us about saying, this other party has either done or not done this thing, and we want to do X, I mean, one of the first things that I always do is say, look, do you have a written agreement? And if you do, well, let me take a look at it. Let me kind of look at what the agreement says, and compare that to what you're describing to me is the current situation and state of affairs. Because oftentimes, I mean, right now, look, everybody is drinking from a fire hose as far as these issues. And so what my hope is that even if you can't get out of a contract, for example, you can look at a way to, not be a zero-sum game. I mean, if you feel like you're going to have to cancel a contract or an obligation or a commitment that you have to someone, instead of just kind of walking away, one of the other approaches that, we've been employing in a couple of different scenarios that I'm thinking of is, how do you look to the future? Maybe it's not in the next quarter or even in the next 6 months, but maybe it's in the next year. Say, look, we don't know that we're going to be able to fulfill this obligation, but under the circumstances, if you will give us some leeway and work with us here, we would be willing to commit to, a similar obligation moving forward into the future. And, I'm not suggesting that that is always a viable option or approach, but sometimes coming back to the other side with a give in these situations is a viable option, because if a business that you're dealing with on the other side of the table is experiencing some of the same challenges that you all are, the proposition of having nothing or maybe having something in the future is a better outcome than having nothing at all. And so I've been seeing a lot of negotiations like that going on recently. So
thanks, Travis. That was really helpful. So the big message there is make sure that, everything is fluid, is what I'm hearing. It's a great opportunity. Don't feel like you are beholden to the contracts. Use this opportunity to potentially renegotiate leases, renegotiate contracts, etc. And it sounds like there's a lot of entities that are all in a place of uncertainty. So certainly those contracts, those agreements that may be specifically painful for your business, this may be a good opportunity to just revisit and have some sort of good faith conversations.
Absolutely. And just to kind of build on that, I think I always like to start with what is the state of affairs? Are we in a bad position? Are we in a good position? Are we kind of in a muddy middle position that we're not sure what the outcome would be currently? And that helps you know what the strength of your position is, right? If there's no question that you're in the right and the other party is in the wrong from a contractual standpoint, that does give you bargaining power and position to, address it in a financially and maybe, non-financial way. But it changes. If you know that you're sunk, if your position is terrible, then you're going to find yourself looking at other viable alternatives to negotiate. And here's just one example. We had a client who was a landlord for commercial space, and whenever COVID hit, they had a whole bunch of tenants just send them. The first letter came that because of COVID, we're not going to pay our rent next month. Okay, we're just not going to. There was nothing in the contract that said that they had an out or whatever. And of course, taking that position from the get-go kind of puts everybody immediately at odds, right? Instead of picking up the phone and saying, we're concerned about what the next 6 weeks of our business operations look like, either because there is a stay-at-home order or because imports are shut down from other countries for our raw material suppliers, or whatever the situation is, that immediately puts everybody at odds. If you're the landlord and I'm the tenant and I come to you and say, Hershu, COVID's hit, I'm sorry, I'm just not going to pay my rent, you immediately say, well, I still have a note on this property and I still have to make my mortgage payment on this property, right? And what option does that then leave you? And so then, many landlord, whether it's commercial or residential, I mean, many landlords, well, their initial response is, well, I'm going to evict you then, right? I mean, if you're going to breach the lease, then I'm going to evict you. And that immediately puts people at odds. And that isn't a great a great starting shot, in my opinion, to try and work through it. I mean, most of the business clients that I have, regardless of which side of the table they're on, I mean, if they have the other side come to them and say, hey, we're worried about this situation, we have concerns about cash flow, we have concerns about viability over the next month. I mean, if you have a good business relationship with folks, I mean, oftentimes they're willing to hear you out and make some accommodation, renegotiate the contract, forbear rent payment, and maybe make a catch-up plan over the next quarter or whatever. I mean, most people are in business to make money, but they also recognize that they have to have customers in order to be in business and make money. And so there's always that give and take. But whenever not every job needs a sledgehammer as the right tool for the job, right? I mean, sometimes you need a hacksaw, sometimes you need a screwdriver. And so every job is not made for a sledgehammer. And I think that that's a pretty good general principle to apply, especially in these tough times, because I mean, there have been tons of small businesses that have been terribly negatively affected, either because they were required to shut down or they felt like they had to shut down. I've had, employers who have had employees who just refused to come to work, and they didn't have a workforce to be able to continue operations. Many manufacturing facilities have been, either hit with outbreaks of COVID or, a reluctance of employees to come to work or whatever. And, or because of social distancing requirements, employers have had to scale down production because they can't have as many people on the production floor. And so I think because everyone is affected just in a different way, I mean, people are fairly receptive to, let's make this work. Let's not just completely shut the whole thing down. But it does require a little bit of, sometimes you have to have hat in hand. Sometimes you have to be willing to consider the other person's position and how bad your position is if you're going to have to go to the mat on it. And being honest about those first impression kind of analysis helps people make better decisions. Because I have to have hard conversations with clients. Sometimes clients want to take a really strong position. We look at it and I say, your position isn't as strong as maybe what you hoped it would be, but it's okay. We can still deal with that. It's just the way that we deal with it is different.
Sure. That's really helpful, Travis. There's a question that's also come in. Let me just read that to you really quick. 1 second. The question comes from our community in Herman, and the question is from Becky Jekka. Specifically, can someone actually claim they got sick at your place when no one else is staying but them? So she's talking, I believe, about a lodging facility. And what do you do in particular outside our contractors and employees, and of course, cleaning crew? So how do we deal with if someone gets COVID on premise, whether in this case, I believe she's talking about lodging establishments, et cetera?
Sure. So I'm going to start with a very in the weeds comment here because I have this conversation a lot. I think one of the hard things to know is, are claims going to come that are of that nature? And I can only assume that they will come. The question is just how many and how widespread will it be? And the good news about this is, I mean, COVID in that regard is likely going to be treated not that much differently than, any other contagious or communicable disease. The only difference is kind of the magnitude and people's awareness of it. And so, whenever you talk about potential liability for those kinds of claims, I mean, the old negligence standard still applies. Number one, you have to have some sort of legal duty. There has to be a breach of that duty. There has to be some causation between your duty to either do or not do something and your breach of that duty. I mean, there has to be some sort of logical connection between those two. And then there have to be damages. And so I think that on the plus side or the good side from a proprietor standpoint is I mean, proving that a customer, contracted the virus or was subjected to it at a particular facility in general may be somewhat difficult. Having said that, I think that on the flip side of that, while contract tracing from a public health perspective is helpful in order to make people aware about whether they've been subjected to potential, contraction of the virus. At the same time, it also kind of creates this bank of evidence about, well, was this person who has tested positive for COVID then at places X, Y, and Z? And so that's going to be relevant. And if those cases come, the person who contracts the virus having to prove that they contracted it at a particular establishment is a burden that rests on them. So nothing about that has really changed because of COVID. I think that, as far as whenever we talk about risk mitigation, I think that that's maybe where the analysis is a little bit different. And again, I think it depends on everyone's appetite for risk. I know some lodging facilities have done a number of different things to address these issues. They've had what I kind of, in layman's terms, call a cool down period on rooms, room usage. They're not booking every room every night. They're alternating rooms and, providing for kind of a cool down period. I don't know if that works for every facility or not. It probably doesn't work for every facility. Obviously additional cleaning and trying to follow CDC guidelines, trying to follow, the health experts guidelines about what are appropriate levels of cleaning are good. If I think you have to figure out what is the right fit for, your particular business. And, it's what I like to affectionately call the Goldilocks Principle, right? You don't want the bed that's too big or the bed that's too small. You want the bed that's just right. You don't want the porridge that's too hot or too cold. You want the porridge that's just right. And so you kind of have to figure out where is your risk tolerance at, and then, what measures can you reasonably put into place? I've mentioned masks a lot. That's the big subject of discussion, but there's lots of other preventative measures with, from an employee and management or supervisor's perspective. Make sure that your employees are washing their hands regularly. If they are showing symptoms or have a fever, make sure that you give them the opportunity to stay home and don't require them to come to work. And certainly whenever it comes to third parties, whether it's vendors, contractors, what have you, if they're coming onto your property, you have a reasonable ability to, say, hey, we have concerns about either this person or what have you, and trying to find a solution that doesn't, cause the potential for additional, problems. So I know that probably isn't very technical advice, but I think from a risk management perspective, that's the kinds of things that you have to be looking at doing and managing your risk. And some people are more risk adverse than others. And that's a conversation that I probably have daily with my clients is, how much risk are you willing to chew? How much are you willing to bite off? And on the other hand, how much preventative measures are you willing to put into place, and the time, money, and effort that it takes to do those? And you kind of have to look at it from the benefit analysis side too. You can't eliminate all risk all the time. You can only eliminate some of the risk some of the time, and you have to compare that to how much benefit does it give to you in return for your risk assessment. And I think that lodging is one industry that the question was potentially specifically directed toward, but it's the same thing in the restaurant industry. The restaurant industry has probably been hit as hard as anyone. The lodging industry has been hit as hard as anyone. And those types of public facing businesses do have unique challenges because, there's a range of options. If there's someone who comes in your doors that doesn't meet with what your level of risk is, are you willing to ask them to leave? with the trade-off being that that may make that customer mad, and that customer may tell other people. On the flip side, you may very well say, if they're not willing to abide by our guidelines, we're okay, in order to protect the health and safety of our other patrons and our employees, of making that customer mad, and that's a business decision. You know, I mean, there's a legal element of it, but you don't want to confuse the legal analysis with the business decision that's tied up with that.
Thank you, Travis. My apologies. My computer was acting up a bit. No, that's a great answer. Another question that's come up is something along these lines. If you, as the local laws and regulations are changing, whether to have masks on, mandatory or not, do you as a business have to do you have to set a lower bar or a higher bar than what the local county or the community or the state's enforcing, because those regulations seem to be fluctuating a bit depending on how the COVID cases are evolving. So given that you can't really look at the county or the state for an objective and concrete guidance, is it more conducive to establish a more rigorous, so for your business, making masks mandatory as a preventative approach to ensure that you are not at a legal risk in 4 weeks, when potentially at that point there is a state mandate in place? How do you think about mandates versus a business setting its own parameters?
Sure. So, the easy question is, for a business located in any particular jurisdiction, I mean, technically speaking, the first and foremost consideration at any point in time is know what your local laws and ordinances require and comply with them. I mean, that's kind of the base level, easy legal response. Because most businesses, regardless of whether you think the law is a good idea or a bad idea, most businesses want to comply. And even if they don't want to comply from, a business standpoint, you also don't want to necessarily be in the position of being the non-compliant business who's breaking the law. I think that's the easy question. And I mean, I'm going to, unless somebody wants to hear my personal feelings, which I probably wouldn't address here, I mean, there are appropriate methods and legal procedures to engage in if you don't agree or you have a problem with the way, a particular law or ordinance is written. So I think that goes without saying, but I wanted to point that out. The other piece of that is much more difficult, and it's difficult for all of us, because I get these specific questions every day, and every business is probably asking themselves those questions along the way. It feels like there is no consistency, and some of that is completely understandable because, at the beginning of 2020, no one had ever heard the word coronavirus, and not many people knew anything about it. And as more information is gathered, more data sets are collected, and we learn more about it, of course, it's not unexpected that the guidance and direction and decisions being made are going to change somewhat. So I think starting at a base level of complying with, the required laws of federal, state, and local government, that's a good starting point. And then, whether you go further or not is a very difficult decision. I mean, I don't want to pull punches and make it sound like it's just, another day in paradise as far as deciding whether you go further or not. I think it does tie in nicely with the discussion about, what's your appetite for risk? Are you concerned about, your workforce, the health and safety of your workforce and the public? Are you concerned about, if you go further, what kind of cost that's going to have? for your business or your employees or the public. And so I think those are very difficult decisions to make, but not impossible. You know, I mean, at the end of the day, whenever you circle back to the liability question, you know, almost all liability is in the form of questions of whether someone was negligent or not. What would a reasonable person do? And so if going above and beyond what is required of a business is unworkable, unreasonable, you know, financially not viable, then you can ask yourself the question, you know, if a reasonable person were asked, what should I have done? And you say, this is too much and too far, then that may help make that decision a little bit easier. Now, of course, the difficult thing is reasonable minds can differ about what is appropriate and what's not. And that's okay. But if you're operating within that middle band, maybe that middle 60% band, you're probably going to be okay in general. It's whenever you start drastically deviating from, you know, what would commonly be accepted. If you take that 60% average and you're way outside of that, that's probably where your risk goes up the highest. And so in an abstract way, that's how I think about that problem. You know, I mean, obviously we've seen a lot of small and large businesses take varying sorts of preventative measures because I'm sure they did exactly what we're talking about here today. They did some sort of, I mean, the fancy word is risk assessment, but the common sense term is they talk about where their business, how their business needs to respond to these challenges. And they've decided to draw the line, you know, either requiring masks or, you know, I've seen lots of businesses at this point, we're used to them now. We see the X's on the tile in the store, and we see the signs and those sorts of things, you know, and so I think that those kinds of discussions are important to have before you have a problem. And that's one of the things that I guess I would stress is don't wait until you have a problem to discuss what you should do. I mean, discuss what you should do. And that way, you know, you're trying to prevent a problem, but even if you do have a problem, you can at least be ready with a response and how you're going to deal with it at that point, instead of being reactionary, being proactive. It always helps a lot because, you know, whenever you're caught off guard with a problem, you're having to start from scratch. Whereas if you have those discussions and go through that thought process in advance, it's a lot less jarring.
Sure. Thank you, Travis. That's sagely advice. And just to repeat what you said, obviously we're in turbulent waters. Many of our partners, whether it's state legislature, federal legislature, local leaders, we're all trying to figure out what the path forward looks like. And given that we are right now, the COVID situation is not on the mend. We are seeing a continuing rise in the numbers. So we do expect the turbulence to be furthered in the next few weeks. So the one message I'm hearing loud and clear is at least make sure that, one, you understand what your legal requirements are currently. Make sure you're at least compliant with those. And then as a next step, consult and get a consultant, an advisor who can, a legal expert who can guide you on how your business is operating, and just make sure you have a good risk mitigation plan. Because the world will continue to shift, but at least if you have some good guidance alongside that can make the pathway a bit more steady.
I think that's right, Hirshu. And, you know, one thing that there's always kind of some risk in doing this, but for those folks who are concerned about potential liability, you know, if you do that risk assessment, it's always helpful to document it, right? Because, I mean, number one, if you're not complying with the law, anyone who, say, contracts COVID and they claim it's at your business that they contracted it, you know, their first argument is always going to be that you weren't complying with the law and therefore you were per se negligent. And there's, you know, some fairly good, you know, long precedent across the country of that being the case. You know, if you don't follow the legal requirements and someone gets hurt or injured as a result, that's not a best case scenario for the business. And then, beyond that, so if you have that and you have done a risk assessment, and it doesn't have to be fancy, it doesn't have to be, it doesn't have to be pretty work product, but if claims do come and you have that documentation that look, we sat down and kind of took an accounting of our circumstances, and we made the best decisions based upon the currently available information to do the things that we were doing, and you're then later questioning, well, why didn't you do X, Y, and Z? Documentation always really helps, as long as you don't say something foolish and ill-advised in your documentation, right? And so, there is a give and a take there. If you're going to put it in writing, make sure that it is well thought out and it's not flippant.
Sure.
But it can serve as a backstop to, whether claims are legitimate or not. It serves as a good defense to say, look, we did take preventative measures as a result of our assessment of where we thought we were at. That helps.
Great. Hey, Tanya, I was monitoring the different chat lines. I didn't see anything else come in. Did you have anything else, Tanya? Any questions?
Yeah, I do. This one's a little bit of a different, this is more on kind of employer-employee relations, but I've talked to some different businesses, and in the callback period, they've had some employees that have refused to come back because they're scared. The businesses are taking the precautions, they're following recommendations and stuff. So the question that's being asked is, how long does that business have to wait to give that person to come back, and then before they can terminate? And then, because they've got an empty position here, and they need employees to fill those positions. So that's kind of the question that's coming, is how long do they have to give somebody to come back before they can terminate?
Sure. So I'll give a couple of caveats, just at the risk of painting too broad of a brush here. I'm assuming we're talking about an at-will employee situation, as opposed to someone who has a written agreement for a certain period or term of service. We're not talking about an employee who's subject to a collective bargaining agreement with a union. So we're just talking about an at-will employee. The technical legal answer is, if they're, of course, you have Americans with Disabilities Act obligations. You have potentially, depending upon the size and nature of your business, you might have Family Medical Leave Act requirements that play into your decision making there. But if all of those legal obligations are satisfied, and they are otherwise cleared to come back to work, they don't have a doctor's note saying that they need to stay at home either because they're contagious or some other health conditions preventing them from performing the essential functions of their job. There's lots of caveats right there, because it's kind of a technical piece of the law. But at the end of the day, if that employee is able to come back to work, and the employer is ready for them to come back to work, and there's nothing standing in their way, and the employee just says, I don't want to come back for whatever reason, there's a couple of strategies that you can engage in. One, communication with an employee in that situation is always key, to make sure that there's not something that you can do within reason to give them a sense of, safety, security, and coming back to the workplace without undue risk. Those conversations, even though arguably they're not required by the law, assuming we're not talking about the ADA, those conversations help. But at the end of the day, if they're not willing to, there's no timeline for saying, well, you have until X and such day to come back. If they're at will and you have work that you're prepared for them to come to work and perform, and they are unwilling to do so, and there's no legal reason why they can't come back, technically speaking, the employer can terminate their employment, or, you can engage in some other strategies. If you want to hire somebody else and take a wait and see approach about whether, you would allow that employee to come back at some point in the future, you could have that conversation too. I've had that situation happen over the past 120 days where there were employees who just didn't want to come back. And so the employer said, you don't have to come back. We'll be happy to consider you eligible for rehire, but we're considering you to have voluntarily quit, and we are going to replace your your position with someone else. And that's okay. I mean, as long as you check all of those legal boxes, there's no set time period for that requirement. And I mean, you kind of have to evaluate your business situation, your workforce, the relationship you have with your employees. I mean, I have some employer clients who are much more sensitive to taking those kind of, I mean, some employers view that as a very hard-nosed approach to doing business. Other employers view that as simply the employee relationship at work. And if you don't have someone who's able to come and work, whenever they need to, that you can't limp along and continue doing business without that employee showing up. And so those are both valid approaches. It's just a different philosophy that gets used in, management decisions.
Thanks, Travis. And thanks, Tanya. Great question. We'll wrap our conversation up. We're just a few minutes over our committed time. So, Travis, thank you so much. You've been just a fountain of insights for our businesses. So we appreciate that. I wanted to make one quick yes, of course. And for anyone on the call, if you're looking for incremental guidance, is it okay Travis, if I share your email address on the Facebook lines?
Sure.
Okay, so we'll do that. Great. Yep. We'll do that. Real quick, I wanted to mention to all potential listeners, the PPP loan/grant deadline has been extended. And I know there's several video recordings we have on what that entails. It's a really great opportunity to access funding. If you missed some of our content, please go to Business 911 or your local business chamber sites, and you can see some recordings there. Can't encourage our small businesses enough to participate in that process. And finally, if you do have a moment, please fill the survey out and let us know how we can continue to improve the content on these events. Next month, we have got a great business leader lined up. We've got Dan Meehan, who's the CEO and president of Missouri Chamber of Commerce. And obviously, with the evolving world of business climate, we're inviting him to share with us what he's seeing happen around the corner. So hope you can join us that day as well. With that, we will wrap up. We want to thank all our chamber leaders, our Grow community leaders for participating in the program. Be healthy, be safe, everybody, and we will talk to you soon. Take care. Thanks, everybody.
Thank you.